I've been an airline labor attorney for about 30 years. I have never in that time met an aircraft mechanic who was told by his manager, "Thank you for finding that crack in the fuselage," or a pilot who was told, "Kudos for finding that hydraulic leak during your walk around," or a flight attendant was told, "We commend you for removing yourself from service based on your fatigue." In my experience, safety first among airline management is very much an empty slogan. They are focused on getting the planes out and reducing costs. And to a great extent in this airline industry, safety rests with the individual conscientious person who won't back down when safety is about to be compromised. Now there's a federal law, an anti-discrimination law referred to as Air 21, that prohibits an airline employer from engaging in retaliatory action against an airline employee for raising safety issues to the employer or to the FAA. So this is going to be a kitchen table conversation that runs you through the elements of the Air 21 statute. Those elements including protected activity. So what does the law entitle you to engage in with respect to conduct? The concept of supervisory knowledge, how important it is under the statute to be able to show that your supervisor had knowledge of your protected activity, and means by which you can ensure that you have that evidence. The concept of adverse employment action, in other words, what is prohibited in terms of retaliatory action by the employer. The limitations period, how long do you have to bring the action after you've suffered the adverse employment action, and the category of remedy, compensatory damage, attorney's fees, make whole relief, the full panoply of remedies that you are entitled to under the Act. What does the Air 21 whistleblower statute cover in terms of protected activity? How is that term defined? The essence of it is the protection of your right to bring to the attention of your airline employer, an airline contractor, or the Federal Aviation Administration, your reasonable belief that there has been non-compliance with federal aviation standards. You are not required to cite a statute. You are not required to cite a regulation. It is sufficient that you bring to the attention of the employer or the FAA facts which would, in your reasonable belief, constitute a violation of a federal aviation standard. For a mechanic, it could be, this tool is not approved by the manual, don't make me do this work with this tool, or this non-conforming part. For a pilot, it might be, there are hazardous conditions. There's a dust cloud on the horizon. I don't think it would be safe to fly the plane under these conditions. For a flight attendant, it might be there's an unruly passenger who is inebriated, who ought to be deplaned in order for this flight to be safe. These are all forms of protected activity. And as I have alluded to, you don't even have to be right so long as you had a reasonable belief. Federal aviation standards not only include regulatory standards, but also sources that are required to be implemented under federal aviation regulations. So for example, a mechanic bringing to the attention of his employer non-conformance with the maintenance manual, a pilot citing non-compliance with his FOM, or a flight attendant saying the flight attendant manual does not permit certain actions. All of these communications to management or to the FAA would be protected activity under Air 21, and therefore it would be prohibited under federal law for the employer to engage in any retaliatory action. Another source of protected activity is filing the complaint itself. So once you file that complaint, even if ultimately that complaint is found to be without merit, the fact that you filed that complaint is protected activity, and it is prohibited under federal law to engage in any retaliation against you based on the fact that you filed that complaint or supported another person's Air 21 complaint. The Air 21 whistleblower statute is an anti-discrimination law, And therefore, you are going to be required to demonstrate the subjective intent of your supervisor or management to discriminate against you based on your protected activity. That's going to require you to establish the knowledge of your supervisor that you engaged in protected activity. To reference an analogy to Title VII, you have a greater burden than the black employee who goes in, who doesn't have to establish that he's black. That's visible, everyone knows it. Think of it as more analogous to the pregnant woman who maybe 6 months in is not going to have an evidentiary issue, but 1 or 2 months in, if she's not showing, she's going to have to show that the person who discriminated against her or allegedly discriminated against her had that knowledge. She's better off saying to everyone, hey, I'm pregnant, so that she can acquire the protection of the Pregnancy Discrimination Act. Think of yourselves in that same situation. When you bring your noncompliance notification to management, you want to do that with witnesses, or you want to do that in writing or via email, and you want the knowledge of this to be as widespread as possible. If you're sending that email out, CC it to anyone who would be in a position to take retaliatory action against you. We've seen management play games in this situation. Well, manager A knows of the protected activity, so we'll fish out manager B to engage in the retaliation. And then you have an evidentiary issue. This is a factor, the requirement that you establish supervisory knowledge, that you might want to consider when you contemplate availing yourself of an ASAP program or some other anonymous complaint mechanism. That sounds good on its face, but the pretext of anonymity, or the pretense of anonymity, which oftentimes doesn't really exist, becomes a shield for the employer, protecting management against liability based on the purported lack of knowledge. So now you've learned that there is a federal statute known as the Air 21 Whistleblower Statute that protects your right to engage in protected activity, essentially bringing noncompliance with federal aviation standards to the attention of the FAA or to the employer, and prohibits, in that context, the employer from engaging in any type of retaliatory action. This is known as an adverse employment action. So it's important that you know what's the scope of an adverse employment action. It's not just the obvious items, such as termination, demotion, failure to promote. It can cover more subtle actions, such as denial of the opportunity to work overtime. It could be a written warning, or even oral counseling in some cases has been found to be an adverse employment action. The government casts a wide net because they want you out there reporting these issues of noncompliance to the employer or to the FAA. And therefore, any action by the employer that has the impact and intent of intimidating you or chilling you in your desire to report noncompliance could constitute adverse employment action under the Air 21 Whistleblower Statute. We're going to assume that you have engaged in protected activity as defined by the Air 21 statute. You've brought to your employer's attention noncompliance with some federal aviation standard, and now, subsequently, you've suffered some adverse employment action. How do you show the nexus between the two? How do you show causation? Now, generally, employers are not stupid enough to give you a letter saying we're engaging in retaliation now against you because you brought this safety issue to our attention. Although don't overestimate them, because we have had situations where an employer has said, you found a crack in the fuselage outside your work area, and therefore we are going to punish you, discipline you for reporting this crack. So sometimes they are that stupid. But the administrative law judges, recognizing that most employers are not that stupid, will allow certain elements of evidence to establish an adverse inference. What am I talking about? One example is temporal proximity. If you engage in protected activity and within a few months, and there's one case that established even 8 months as a relevant time period to draw an adverse inference. If one followed the other within several months, the judge is entitled to draw an inference that one caused the other. Also, when you suffer the adverse employment action, what are the rationales that the employer provided for this action? Were they pretextual? Was everyone allowed to come 5 minutes late except for you? Were there shifting rationales, that alternative rationales were provided for the adverse employment action? Or was the rationale for the adverse employment action withheld and never provided? In all these situations, administrative law judges under Air 21 have found that this is sufficient to establish causation between the adverse employment action and the preceding protected activity, sufficient so that the burden of proof is shifted to the employer. One other piece of good news, under this statute, you do not have to show that the protected activity was the primary factor in the adverse employment action you subsequently suffered. All you have to show to shift the burden to the employer is that it was a contributing factor, that your protected activity, your communication of noncompliance with a federal aviation standard was a factor, a partial factor, driving the adverse employment action that you suffered. So now, as an airline employee, you've engaged in protected activities. For example, you've brought to your employer's attention noncompliance with the maintenance manual, or the FOM, or the flight attendant manual, and subsequently you suffered an adverse employment action. You were fired, you got a written warning, you were brought in for harsh interrogation, you were forced to submit to some medical examination. How long do you have to file a complaint? This is one of the perhaps weak elements of what's otherwise a very strong federal law that favors the employee. You only have 90 days from the date of the adverse action to file that complaint. Now, you can do that yourself, and it doesn't have to cost you a nickel. You go to the OSHA website, you get the information, you submit the complaint and list out your protected activity and the adverse employment action that you suffered. Or you can consult with an attorney to help you frame this in the best way possible. But in any case, get the complaint in within the 90 days. You can always amend later. And also remember, the action of filing the complaint itself is protected activity. So you don't have to keep that secret. You might let all your supervisors know that you filed a complaint, because once they have knowledge that you filed that complaint, they're going to be intimidated themselves from retaliating against you for having brought that action. That would be prohibited under federal law. Okay, let's now talk about remedies under the Air 21 Whistleblower Statute. You're an airline employee that has brought to your employer's attention or the FAA's attention noncompliance with federal aviation standards. You've suffered an adverse employment action, and the administrative law judge is going to decide in your favor. What are you entitled to? Well, for starters, the make-whole relief that an arbitrator might award a union employee, meaning back pay for lost wages, the value of lost medical benefits. But the remedial provisions of Air 21 go well beyond that. Administrative law judges are authorized to award you your reasonable attorney's fees. They can award you compensatory damages for pain and suffering and mental distress. They can award affirmative relief, such as the purging of your personnel file of all adverse disciplinary action, or a posting in the workplace advising that the employer has violated the statute. This wide scope of remedial tools is designed to encourage you to put some starch in your shorts, to dig in your heels and tell the manager, no, I'm not going to do this. Now, we know not only are the managers pushing you, but also passengers, because they want to get from point A to point B. And sometimes we're driven to think of them as cattle pushing up against the gate, or hordes of ingrates who don't understand what you do day to day. But let's be plain about this. Their safety does not rest in the hands of the managers, who are graded on how many planes are in or out of service at any given time. Their safety depends on you. It rests in your hands. And consider yourselves blessed that you're American citizens in a country that's governed by the rule of law, and blessed as airline employees that this statute was enacted for your protection. Make use of it, because it's not only your legal right, but many times it truly is your moral obligation. Thanks for listening.